You know, usually when we talk about a blueprint, there's this underlying expectation of perfect translation.
Great.
Like, think about architecture. You look at an architect's schematic, you see the clean lines, the majestic pillars, the precise structural measurements, and you assume the builder just takes that paper, does the work, and eventually points at the finished skyscraper and says, there it is.
Yeah, the plan just magically becomes a reality.
Exactly. It's a comforting thought. We inherently want grand designs, especially legal or societal ones, to just simply materialize exactly as they are drawn.
We want that transition from concept to concrete to be completely seamless.
But then you step into the world of human rights law, and suddenly that transition from a pristine blueprint to a functioning reality is, well, it's an absolute construction site.
Oh, for sure. It really is.
You're looking at a legal landscape that is incredibly messy, full of compromises, structural bottlenecks, and just constant friction.
I mean, that friction is perhaps the most defining characteristic of human rights protection.
Right.
The ideals, the declarations of universal rights, they're beautiful and inspiring. But the actual machinery required to protect those ideals is immensely complicated.
Yeah, a constitution can promise you the world, but if there isn't a specific desk you can walk up to or a functional court you can appeal to when those rights are violated, the words are functionally just ink on a page.
Exactly. And that structural reality is what we are digging into today.
Welcome to the deep dive. We are looking at a truly fascinating stack of sources today that center around how a massive democracy actually attempts to police itself.
We're working with UN parliamentary handbooks, the actual legislative text of the Protection of Human Rights Act of 1993, often referred to as the PHRA.
Right, the PHRA. And we're anchoring all of this around a comprehensive legal framework. We are diving into Unit V of a constitutional law syllabus, specifically the kind of rigorous material you would find taught by a law professor at Osmania University.
Focusing entirely on the structural protection of human rights in India.
So our mission here is to completely demystify this machinery for you. We are moving past the lofty rhetoric of international declarations and examining the ground-level mechanics.
The commissions, the courts, the specific legislative clauses, and the deliberate bureaucratic structures.
The actual gears that attempt to turn human rights from abstract concepts into enforceable realities for over 1 billion people.
It's a massive undertaking.
Okay, let's unpack this. We are going to avoid getting bogged down in dry textbook jargon and focus entirely on the power dynamics and the structural engineering of this law.
Good call.
Because when you look at the origins of the 1993 Act, it becomes clear that this legislation didn't just casually emerge during a quiet legislative session. There was a very specific historical catalyst.
Yeah, the historical backdrop is absolutely essential for understanding the DNA of the Act. What's fascinating here is that the concept of having domestic, national-level institutions dedicated to protecting human rights wasn't a novel idea invented in the 90s.
Wait, really? It feels very much like a 90s concept.
I know, right? But our sources show that the United Nations Educational, Scientific, and Cultural Organization, UNESCO, actually proposed this idea way back in 1946.
Wow. So right in the immediate aftermath of World War II.
Exactly. Right after the horrors of the war, there's this massive global push for universal human rights.
But it didn't really go anywhere right away, did it?
Well, the Universal Declaration of Human Rights gets passed in 1948, but the idea of national watchdog institutions just sort of simmered.
But the Cold War took over, I imagine.
Yeah, exactly. Nations became incredibly protective of their sovereignty. The idea of setting up internal monitors didn't gain real, actionable traction globally for decades.
So when did it actually start moving?
It wasn't until the late 1970s that the UN Human Rights Commission started aggressively pushing member states to establish these local institutions.
But even then, the architecture for these institutions was still pretty vague until 1991, right? That seems to be the global watershed moment in the source material.
Spot on. 1991 is the critical turning point globally. That is when the Paris Principles were drafted.
And what exactly are those? Like, what did they do?
These principles essentially established the baseline credibility guidelines for any national human rights institution. The international community realized that governments could easily set up fake watchdogs.
Oh, like institutions that existed just to rubber stamp government actions. A PR move, basically.
Exactly. So the Paris Principles dictated that if a country was going to set up a true human rights watchdog, It had to meet specific criteria.
Such as?
It had to be independent from the executive branch. It had to have a broad legislative mandate, adequate and secure funding, and pluralistic representation from civil society. It was a global standard for genuine accountability.
Okay, so you have this mounting international standard, but looking at the sources regarding India specifically, the early 1990s was a period of intense domestic and international pressure.
Immense pressure, yeah.
India was going through massive economic liberalization, but politically and security-wise, there were these huge external pressure points.
Yes. India was facing vocal and sustained criticism from Western countries and major international human rights organizations.
And this wasn't just abstract criticism.
No, it was specifically targeted at alleged human rights violations committed by armed forces and paramilitary units in highly sensitive, conflict-prone regions.
Specifically, Jammu and Kashmir, the Northeast, and Andhra Pradesh, according to the text.
Right. There were serious allegations of excesses, and the international community was demanding visible institutional accountability.
And the government's response to this pressure is fascinating when you look at the timeline. It wasn't some slow, multi-year committee process. The action was remarkably sudden.
It really was.
On September 27, 1993, the President of India promulgated an ordinance to create the National Human Rights Commission, the NHRC. They immediately appointed Justice Ranganath Misra as its first chairperson.
And then, just a few months later, the Lok Sabha passed a bill to replace that ordinance, receiving presidential assent in January 1994.
Which is lightning fast for any government.
The mechanism they used, an ordinance, speaks volumes. An ordinance is typically utilized for matters of extreme urgency when Parliament is not in session.
Right.
Using it to establish the NHRC underscores how pressing this issue was for the government. They needed to signal to the international community and to domestic civil society that they were taking immediate action to align with those Paris principles.
But looking at this logically, it raises a massive paradox.
Oh, the inherent paradox of a state watchdog.
Yeah. If the government, and specifically its security apparatus, was the entity facing criticism for alleged violations, how does it make sense that the government is the one creating the watchdog to monitor itself?
It's a great question.
I mean, how does a statutory body created by the state actually hold the state accountable without simply functioning as a protective shield?
That is the central tension of any statutory regulatory body. And it's the most critical question we can ask. The way the PHRA was engineered, and this is where we see the sophisticated legal drafting in the Osmini University materials, was to force accountability by moving the power of protection into an independent statutory mechanism.
Okay, so they essentially tied their own hands.
Exactly. By anchoring the NHRC in a strict legislative framework, the government was legally binding itself. They had to fulfill international expectations, they had to respond to domestic civil society, and they couldn't do that with a weak institution.
Because if they did, the international community would have seen right through it.
Precisely. The law had to be designed to give the Commission structural independence, or it would have been dismissed internationally on day one.
Which brings us to part 2, how you actually design an institution to withstand state pressure. Looking at Section 3 of the Act, which details the composition of the NHRC, the requirements are staggeringly strict.
The composition is exceptionally rigorous, and it has to be.
Like, I was reading this and thinking, you don't just get appointed to the NHRC because you have political connections.
No, absolutely not.
The Act mandates that the chairperson must be a former Chief Justice of the Supreme Court of India. That alone sets an incredibly high bar.
It ensures that the person leading the commission has the highest possible judicial pedigree in the country, and the rest of the core members are of a similar caliber.
What are the other requirements?
The legislation specifies that the members must include a current or former Supreme Court judge, a current or former Chief Justice of a high court, and 2 members who possess profound practical experience and knowledge in matters relating to human rights.
It's basically an Avengers-level team of legal minds. You have the pinnacle of the Indian judiciary, paired directly with seasoned, on-the-ground human rights experts.
That's a great way to put it. The Supreme Court itself commented on this structure in the case of Karamjit Kaur v. State of Punjab.
Yeah, what did they say?
The court observed that these judges have spent their entire careers explaining, interpreting, and enforcing fundamental rights. They are the ultimate constitutional authorities on the matter.
But the structural vulnerability here is the appointment process, right? If the executive branch handpicks these judges, doesn't that inherently compromise the commission's independence?
If the executive had unilateral power to appoint, yes, the independence would be completely compromised. But Section 4 of the PHRA introduces a vital political counterbalance.
The selection committee.
Exactly. The members are formally appointed by the president, but the president can only act on the recommendation of a highly specific, multi-partisan selection committee.
The makeup of that committee is fascinating. It's chaired by the Prime Minister and includes the Speaker of the House and the Home Minister.
But the crucial element is who else is required to be there.
Right. It legally requires the inclusion of the leaders of the opposition in both houses of Parliament, the Lok Sabha and the Rajya Sabha, as well as the Deputy Chairman of the Council of States.
That bipartisan composition is the bedrock of the NHRC's credibility. The Prime Minister and the Home Minister cannot simply push through a political loyalist.
Because the opposition has a mandatory seat at the table?
Yes, and a powerful voice in the selection process. It legally forces a degree of political consensus. Furthermore, once these members are appointed, they are protected by security of tenure.
So they can't just be fired if the government doesn't like what they're doing.
Exactly. Removing an NHRC member is incredibly difficult. They can only be removed by the president on the grounds of proved misbehavior or incapacity, and crucially, only after a formal inquiry conducted by the Supreme Court.
Wow. That insulation is what allows them to act without fear of immediate political reprisal?
It's vital for their function.
Okay, so you have this fiercely independent, high-powered board, but think about the sheer logistics involved here. I want you to imagine trying to monitor human rights violations across the entire subcontinent of India.
The geographical scale is staggering.
And the demographic complexity. It's overwhelming. 5 former judges and experts, no matter how brilliant, cannot police that landscape alone.
They cannot. The apex leadership requires an immense operational apparatus beneath it. This is why the NHRC is structured as a massive, highly specialized bureaucracy.
Yeah, the legislative texts detail 5 distinct divisions within the Commission's secretariat that do the actual day-to-day heavy lifting.
Let's break those down. First, there's the Law Division, headed by a registrar.
They're the ones receiving, sorting, and legally processing the absolute mountain of complaints that come in from across the country.
Right. Then you have the Investigation Division.
Now, this one caught my attention because it is specifically headed by a Director General of Police. Their mandate is to investigate custodial deaths, violence in police or judicial custody, and encounter deaths.
That specific leadership choice, a Director General of Police, is highly strategic.
Why is that?
Because to effectively investigate the police apparatus, you need seasoned investigators who intimately understand police procedures, internal hierarchies, and how evidence in state custody might be obscured or mishandled.
You essentially need a top-tier cop to police the cops.
Exactly. Then you have the Administration Division, which manages the massive logistics, personnel, and public relations required for an institution of this size.
And the Training Division, right.
Yes, their mandate is to travel and spread human rights literacy, specifically aiming to sensitize government staff, paramilitary forces, and local police.
And finally, the Policy Research Projects and Programs Division. They're the ones looking at the macro level, reviewing systemic issues, analyzing existing laws, and coordinating with civil society organizations.
These 5 divisions form the nervous system of the NHRC. They provide the high-level legal minds at the top with the necessary reach, the investigative capability, and the sheer administrative power to operate on a national scale.
But, you know, the existence of a bureaucracy doesn't necessarily equal real power. What authority does this machine actually wield? Let's examine the powers granted under Section 13 of the PHRA.
This is a crucial point, because a common critique of watchdog institutions is that they are all bark and no bite.
Right. So what does Section 13 actually say?
Section 13 is where the NHRC derives its teeth. The Act explicitly states that while inquiring into complaints under the Act, the NHRC operates with all the powers of a civil court trying a suit under the Code of Civil Procedure.
So this is not a mere advisory capacity. It is a significant level of legal authority.
It really is.
What does that translate to on the ground, practically speaking?
It means they have the legal power to summon anyone in the country and enforce their attendance. They can examine witnesses under oath.
And what about evidence?
Crucially, they have the power of discovery. They can compel the production of any document, receive evidence on affidavits, and requisition public records from any court or government office.
So if a local police department is suspected of a custodial death, and they try to obscure a lockup register or a duty logbook?
The NHRC doesn't just ask politely.
Right.
They have the legal authority to issue a civil court order compelling the police to hand that document over. Refusal to comply is a violation of a court order.
That's a serious level of power. And their functional mandate, outlined in Section 12, is extraordinarily broad, too. They aren't just reacting to complaints.
No, they can proactively intervene in ongoing court proceedings, provided they have the court's approval, if they believe a human rights issue is at stake.
They also have the power to systematically review existing legislation. The Osmania syllabus highlights a prime example: the NHRC's review of the Child Marriage Restraint Act of 1929.
That's a great example of their proactive work. They didn't just read the act and file a report. They actively demanded structural changes.
They recommended significantly higher penalties, right?
Yes, and they pushed to make the offense cognizable and non-bailable, and they argued forcefully that all marriages, regardless of whether they are religious or civil, must be universally registered to prevent exploitation.
They also have a mandate for physical intervention, don't they?
They do. The legislation grants them the right to conduct surprise visits to state institutions. The Supreme Court has actively utilized the NHRC for this purpose,
Directing them to monitor conditions in massive mental hospitals in places like Agra, Gwalior, and Ranchi to ensure that the living conditions of the inmates meet basic human rights standards.
Exactly. And from a citizen's perspective, the mechanism to trigger all this power is designed to be remarkably accessible.
Yeah, if you were to file a complaint right now, you aren't required to hire a specialized lawyer or navigate complex filing fees. You can submit your complaint in any of the recognized languages of India.
It could be a simple letter, an email, or an online submission. They even maintain mobile lines for urgent interventions.
The legislative intent was clearly to remove every possible barrier between a victim and the watchdog.
That was the goal, yes.
However, as you read deeper into the text of the PHRA, you hit some incredibly stark limitations, like glaring limitations.
Yes, Section 36 outlines strict jurisdictional boundaries.
For example, the NHRC cannot investigate complaints against private individuals.
Right, so if a massive corporation displaces a village or a private landlord engages in egregious abuses, the NHRC lacks the statutory authority to intervene.
They also have a strict one-year statute of limitations.
Which is heavily criticized. If you are a victim of a violation and it takes you 2 years to gather the courage or the evidence to come forward, you are legally locked out of their jurisdiction.
And they cannot investigate matters that are already pending before other statutory commissions.
Those limitations are significant, and they often frustrate human rights advocates because they leave massive gaps in accountability, particularly regarding corporate actors and delayed justice.
But the limitation that stands out the most, the one that really defines the boundaries of state power, is Section 19, the Armed Forces Restriction.
Yes, Section 19, this is the big one.
The PHRA explicitly states that while dealing with complaints of human rights violations committed by members of the armed forces, the NHRC cannot conduct an independent investigation.
They cannot send their DGP to question a commanding officer.
Right. They can only seek a report from the central government, and then, based purely on that government-provided report, they can make recommendations.
It's a huge constraint.
So, what does this actually mean for the institution? If they are legally barred from independently investigating the military, especially in regions where the military has an overwhelming presence and where allegations are often the most severe, are they ultimately just a glorified advisory board when it comes to state security forces?
Well, if we connect this to the bigger picture, Section 19 is exactly where domestic and international NGOs direct their fiercest criticism.
Naturally.
The restriction is widely viewed as a protective shield for the state's security apparatus. It reflects the deep-seated tension between human rights oversight and the state's desire for operational autonomy in conflict zones.
But does that make them just an advisory board?
Labeling the NHRC a glorified advisory board misinterprets how they have learned to operate within those constraints.
How do they operate if the law explicitly prevents them from investigating?
They utilize the tools they do have: leverage, transparency, and institutional weight. When the NHRC receives a severe allegation against the armed forces, they request that report from the government.
And what if the report is a whitewash?
If the government returns a report that is clearly inadequate, dismissive, or attempts a cover-up, the NHRC doesn't just file it in a cabinet, they publish their findings.
Oh, wow.
They publicly highlight the inconsistencies in the government's narrative. They leverage the media to generate immense public pressure.
They use the spotlight as a weapon.
Exactly. And more importantly, they utilize their symbiotic relationship with the Supreme Court.
How does that work?
The NHRC will frequently take these inadequate government reports and approach the Supreme Court, acting as a highly credible apex-level petitioner.
Ah, so they use their institutional authority to demand judicial intervention.
Yes, essentially forcing the Supreme Court to order the investigations that the NHRC is statutorily barred from conducting themselves. They find workarounds to ensure the issues are not buried.
That's incredibly clever. So, moving from the structural theory to the actual practice, how has this legal machinery actually impacted lives? The syllabus provides several defining case studies that demonstrate what happens when this institution mobilizes.
These case studies are vital because they show the NHRC operating in entirely different spheres of human rights violations. Take the Punjab mass cremation case, for example.
Which is one of the most significant interventions in the Commission's history.
It is. This was a harrowing situation that occurred between 1984 and 1994, a period marked by intense militancy and severe counterinsurgency operations in the state of Punjab.
The core allegations were that state police forces were secretly cremating the bodies of individuals who had been killed in extrajudicial encounters or who had simply disappeared, officially labeling them as unidentified to avoid accountability.
It's just horrific. A civil society group, the Committee for Information and Initiative on Punjab, brought these terrifying allegations to light.
And the matter eventually reached the Supreme Court, right?
Yes. The court recognized that uncovering the truth required a massive, exhaustive, and highly credible investigation into systemic human rights violations.
A task perfectly suited for the NHRC.
Exactly. The Supreme Court formally referred the matter to the Commission.
And the NHRC undertook this monumental task. Working through years of obscured records and official denials, they managed to meticulously identify 1,388 bodies out of 2,097 previously unidentified cremations.
The sheer investigative rigor required to uncover those identities against the weight of the state apparatus is astounding.
And they didn't stop there.
No, the NHRC didn't stop at identification. They recognized that justice required tangible redress. They ordered the state to provide specific monetary relief totaling over 25 crore rupees, or 2,575.25 lakh, to the families of the victims.
It was a historic effort to provide restorative justice, force state acknowledgement of the atrocities, and offer some measure of closure to thousands of
It
families.
really showed what the Commission was capable of.
The second case study shifts the focus entirely, from state violence to fundamental right to life in the context of extreme systemic poverty, the starvation deaths in Orissa.
Right, this is a completely different type of intervention.
Reports were emerging that a significant number of people were dying of starvation in the impoverished districts of Koraput, Balangir, and Kalahandi.
And, as often happens when extreme poverty leads to death, local administrations almost universally attempt to downplay the crisis.
The standard official narrative is to attribute the deaths to underlying diseases or local epidemics rather than systemic starvation.
Because acknowledging starvation is an admission of total administrative failure.
But the NHRC didn't just request a report from the Orissa government and accept the disease narrative. They actively deployed their own investigative apparatus.
They appointed a special rapporteur whose specific mandate was to physically go to these districts and monitor the state's relief work on the ground.
They forced an emergency response. The NHRC demanded the immediate implementation of emergency feeding programs.
But they also recognized that emergency food drops don't solve the underlying human rights failure.
Right, it's a Band-Aid.
Exactly. They used their mandate to force the state government to conduct a comprehensive review of its entire public distribution system.
They went down to the granular infrastructural level demanding reviews of where tube wells were located to ensure that marginalized and remote communities actually had access to potable water. They acted as a systemic auditor for the right to life.
It's a great example of them using their broad powers.
And then there is the case of the Tripura police violence, which perfectly illustrates how the NHRC functions when the local primary justice system simply shuts its doors to a victim.
This case is infuriating, but so important to understand.
The Asian Center for Human Rights filed a formal complaint regarding the horrific torture and gang rape of a girl by special police officers in the state of Tripura.
The family had attempted to follow the standard legal process, but the local police station completely ignored their complaint.
The local police refused to even record the first information report, the FIR. They denied the victim the absolute most basic step required to initiate the criminal justice process.
The local system had entirely insulated the perpetrators.
Here's where it gets really interesting. The NHRC intervenes. They issue a formal notice directly to the police station in question, and suddenly, miraculously, The local police find the time to record the complaint.
Imagine that. And the state government, clearly recognizing the severity of the NHRC's gaze and attempting to appease the commission, offered the victim's family an interim relief of Rs. 15,000.
But the NHRC rejected that token gesture.
Good for them.
Yeah, they analyzed the sheer brutality of the case and the undeniable systemic failure of the local police to protect a citizen. They ordered the state to pay a significantly higher compensation of Rs. 50,000.
And more importantly, they didn't just close the file. They actively monitored the ensuing criminal case to ensure the local police couldn't quietly drop the investigation once the media attention faded.
Looking at these three incredibly diverse cases, the mass cremations in Punjab, the systemic starvation in Orissa, the local police cover-up in Tripura, a very clear pattern emerges regarding the NHRC's functional identity.
They operate as a structural battering ram when the local doors to justice are deadbolted.
Exactly. When the local police refuse to record a crime, when the state government turns a blind eye to starvation, the NHRC leverages its national authority to forcefully break through that local apathy.
They're designed to be the federal fail-safe for human rights. When the primary machinery fails, they are the override.
But that federal fail-safe role presents an immense logistical nightmare, which brings us to the concept of decentralizing justice, as outlined in Chapter Phi of the PHRA.
Because if the NHRC is headquartered in New Delhi, acting as this apex battering ram, it is mathematically impossible for them to handle the sheer volume of violations occurring across every village, district, and state in the country.
Right. The drafters of the 1993 Act clearly understood that a single centralized commission would be immediately paralyzed by the caseload.
Absolutely. The legislative foresight in the 1993 Act recognized that protection must be localized to be effective. Therefore, Chapter 5 of the PHRA provides the legal framework for the creation of state human rights commissions, or SHRCs.
The legislative intent was to create a decentralized, distributed network of protection.
The mechanism allows state governments to constitute their own state-level commissions under Section 21.
And these SHRCs are granted jurisdiction over alleged human rights violations related to subjects enumerated in List 2 and List 3 of the Constitution's 7th Schedule.
That covers the state list and the concurrent list, which includes critical areas like public order, the functioning of the state police force, and the administration of prisons.
And much like the national body, the law attempts to ensure the independence and caliber of these state commissions. The chairperson of an SHRC must be a former Chief Justice of a high court, establishing a high standard of judicial pedigree at the state level.
So, on paper, it looks like an incredibly robust, distributed system of justice. You have the apex body in Delhi and a specialized high-powered commission in every state capital.
On paper, yeah. But the sources we are reviewing reveal a reality that is starkly different from the legislative blueprint.
It really is.
I'm looking at a specific document, the NHRC's own official submission to the UN Human Rights Council for India's Universal Periodic Review. This is the formal document where India's human rights infrastructure is globally assessed.
And in this submission, the NHRC itself provides a devastating assessment of the state-level commissions.
They state that the central government grants the SHRCs no added powers, and they describe the state commissions, using their own words, as mostly moribund.
Moribund. It is a profound institutional admission.
To describe an entire tier of the human rights infrastructure as moribund, meaning stagnant, completely ineffective, essentially on the verge of death, is a staggering indictment of the decentralized model.
The question is why? Why does the National Commission manage to wield significant power and execute massive interventions, while the legally equivalent state-level commissions fail so comprehensively?
What does the syllabus say about that?
The failure is rooted in the structural mechanics of autonomy and resource allocation. The NHRC, despite its limitations, maintains a significant degree of financial and administrative autonomy from the central government.
This is partly hardwired into the law, right?
Yes, and partly a result of its high international visibility.
Yeah.
The central government cannot easily defund the NHRC without triggering global alarm.
But the state commissions don't have that shield.
Exactly. The state human rights commissions, conversely, are entirely dependent on their respective state governments for everything. They rely on the state for their operational budget, their administrative staff, and crucially, their investigative infrastructure.
And that creates an incredible conflict of interest. The SHRC's primary job is to investigate the state police and state prisons. If a state government has no desire to have an active, aggressive watchdog scrutinizing its security apparatus,
They don't have to actively dismantle the SHRC. They just starve it. The state simply refuses to appoint members, leaving the commission without leadership. They withhold the necessary funds, and they refuse to allocate dedicated, independent police investigators to the commission.
so an SHRC that lacks investigators and a working budget is nothing more than an empty suite of offices with a prestigious nameplate on the door. It is structurally neutralized.
And the consequence of that deliberate starvation is a massive bottleneck for justice. If a citizen in a remote district suffers a human rights violation and their state commission is moribund, their only recourse is to somehow appeal to the NHRC in New Delhi.
That completely defeats the legislative purpose of decentralization. It is like a city building a network of fire stations in every neighborhood, but the mayor refusing to buy any fire trucks. The infrastructure exists purely as an illusion of safety.
That's a perfect analogy. Which brings us to the lowest, most grassroots tier of this machinery, and perhaps the most perplexing failure of the entire 1993 Act.
Let's examine the concept of human rights courts in districts.
This was envisioned as the ultimate, most accessible local remedy. Section 30 of the PHRA empowers state governments to specify, with the concurrence of the Chief Justice of the High Court, an existing court of session in any given district to act as a specialized human rights court.
The explicit stated goal in the legislation is to provide for the speedy trial of offenses arising out of human rights violations.
The Act even mandates that the state must appoint a highly qualified special public prosecutor, an advocate with no less than 7 years of practice, to exclusively try these cases.
When you read the blueprint, it sounds revolutionary. If you experience a human rights violation in your hometown, you don't have to navigate to the state capital or to New Delhi. You go to your local district human rights court, you get a dedicated, experienced prosecutor, and you receive a speedy trial.
But the sources indicate this system is almost entirely non-functional.
Wait, really? Why?
It is non-functional due to a massive, almost inexplicable omission in the drafting of the 1993 Act. The legislature legally mandated the creation of these specialized courts, but they entirely failed to define the jurisdiction.
I don't understand.
They never defined what a human rights offense actually is under Indian criminal law.
That seems like a catastrophic oversight.
It is the defining flaw of Section 30. The Indian Penal Code clearly defines crimes: murder, theft, assault, extortion. But the PHRA never created a specific schedule of crimes or a distinct legal definition of a criminal offense called a human rights violation that these district courts were supposed to adjudicate.
So the courts exist, but they don't have a list of laws they are enforcing.
Exactly. Furthermore, the Act completely failed to outline any specialized procedural rules for how these courts should operate differently from standard criminal courts.
To use a functional metaphor, it's exactly like a government spending millions to build a massive high-tech hospital, hiring all the specialist surgeons, cutting the ribbon, and then completely forgetting to define what diseases the doctors are legally allowed to treat.
Right.
The doctors are just standing around in empty operating rooms, legally unable to admit a single patient.
That perfectly encapsulates the reality. Because of this profound legal ambiguity, the vast majority of states simply never bothered to establish these courts.
The sources note that only a few states, such as Tamil Nadu, Assam, and Uttar Pradesh, made genuine attempts to notify these courts.
But the moment they were established, they were immediately paralyzed by legal confusion. Defense lawyers quite rightly asked, under what specific law is my client being charged? Who has the legal standing to approach this court? What procedural code are we following?
And that systemic confusion led directly to a landmark judicial intervention in 1997. The Madras High Court was essentially forced to step in and try to make sense of the flawed legislation.
Yes. A prominent non-governmental organization, the People's Union for Civil Liberties, the PUCL, filed a memorandum specifically questioning the jurisdiction and procedural mechanics of these newly notified district courts.
The Madras High Court had to intervene to clarify the legislative mess.
The court ultimately ruled that these human rights courts are not newly empowered constitutional entities. They are essentially just special courts functioning within the regular cadre of a court of session. They are bound by the standard code of criminal procedure.
But the most consequential part of that ruling was regarding the power to award compensation, wasn't it?
Crucially, yes. The High Court clarified that because these courts are operating strictly under standard criminal procedure, they only possess the power to grant compensation within the narrow limitations of regular criminal law.
They do not possess the sweeping public law jurisdiction of the high courts or the Supreme Court, which have the authority to award massive structural constitutional damages for fundamental rights violations.
So practically speaking, a victim might get their case heard slightly faster in a designated human rights court, but they are ultimately just getting a standard trial for a standard assault charge.
They are not accessing a specialized, powerful human rights remedy. The entire system is structurally broken at the district level.
This raises an important question. Have there been any serious attempts to amend the Act and fix this specific flaw?
Yeah, you'd think they'd want to fix that.
There have been repeated urgent attempts by the institutions themselves. The NHRC formed the Amati Committee and subsequently the Justice K.G. Balakrishnan Committee with a specific mandate to recommend amendments to Section 30.
What did they recommend?
These committees essentially pleaded with Parliament to amend the Act to clearly define a schedule of human rights offenses, to clarify the jurisdiction, and to establish a distinct operational procedure for these courts.
And how did Parliament respond to those recommendations?
The legislative response has been practically non-existent. When the PHRA was amended in 2006, Parliament entirely ignored the recommendations regarding Section 30.
So the legal ambiguity remains enshrined in the law.
Yes. Even in 2015, when the Supreme Court issued a sweeping landmark order demanding that all states immediately set up these district human rights courts and simultaneously install CCTV cameras in all prisons to deter custodial violence, the core issue persisted.
Because the Supreme Court can order the courts to be established, but without Parliament amending the law to define what those courts actually do, the operational paralysis continues.
It highlights the immense, frustrating gap between passing a noble-sounding law in the halls of Parliament and the brutal, grinding, bureaucratic friction of actually implementing that law at the district level.
You can legislate a court into existence, but if you refuse to define its jurisdiction, you haven't provided justice, you've merely constructed an illusion of it.
Exactly. It's structural theater.
So taking a step back and looking at this entire Osmania University Unit V framework we've just navigated, it is a truly complex journey.
It really is.
We've traced the architecture of human rights protection in India from its origins, born out of the post-WWII UNESCO ideals, crystallized by the 1991 Paris Principles, and forced into existence by intense domestic and international pressure in 1993.
We examined the deliberate, highly calibrated architecture of the NHRC in New Delhi, the requirement for apex judicial experience, the bipartisan political balance of the appointment committee, and the operational muscle of its investigative and legal divisions.
We looked at how they wield their civil court powers, how they review legislation, and how they have historically acted as a battering ram against state apathy in monumental cases like the Punjab mass cremations, the systemic starvation in Orissa, and the localized police violence in Tripura.
But equally, we've dissected the profound structural failures of the blueprint.
Right. We explored the protective shield of Section 19 regarding the armed forces. We discussed the deliberate financial starvation that renders the state human rights commissions moribund.
And we unpacked a catastrophic legislative ambiguity that paralyzes the human rights courts at the district level.
It is a stark reminder that human rights are not merely secured by lofty UN declarations read in international forums. They are actively fought for, negotiated, and often compromised in the messy, bureaucratic, and frequently underfunded trenches of national and state law.
The legislative blueprint may strive for perfection, but the actual institution is a building constantly under construction, constantly facing resistance, and structurally prone to leaks.
And examining that freshen leads to a final, somewhat provocative thought to consider.
What's that?
As we reviewed the entire spectrum of these sources, the monumental interventions, the court rulings, the push for amendments, one specific element was entirely constant. When you look at the Punjab mass cremation case, who spent years gathering the evidence and forcing the issue to the Supreme Court.
It was a Committee for Information and Initiative on Punjab.
Right. In the Tripura police violence case, who brought the ignored FIR to the attention of the NHRC.
The Asian Center for Human Rights.
And when the district courts were mired in legal confusion, who forced the Madras High Court to provide clarity.
The People's Union for Civil Liberties.
The non-governmental organizations. The civil society groups.
Yes, the source material unequivocally demonstrates that the NHRC, despite its immense statutory power, its civil court authority, and its apex-level judicial leadership, relies almost entirely on NGO reporting and civil society advocacy to trigger its mechanisms.
The NGOs serve as the essential eyes and ears of the Commission.
The system is entirely reliant on them to ring the alarm. So the question this leaves us with is this. If the multi-million-dollar statutory bodies, designed and funded by the state to protect human rights, rely so fundamentally on the underfunded, voluntary, and frequently legally harassed civil society to act as their primary sensory organs, who is truly holding the power to protect human rights in a democracy?
Wow.
Is it the institutions created by the legislative blueprint, or is it the relentless citizens operating outside of it?
That is an incredibly powerful question to end on, because it suggests that maybe the blueprint isn't just about the architecture of the institutions. Maybe a functioning blueprint fundamentally requires the friction of an active citizenry to actually make the machinery move.
I think so, yeah.
Thank you for joining us on this deep dive into the structural mechanics of human rights law. Keep questioning the blueprints, and we will catch you next time.